Okay, good evening, everyone. So this is our second class. So do we have any doubt from yesterday? It's clear, it's crystal clear what we discussed. So we'll be beginning with the part 3 of the Constitution, preamble, part 1, part 2 we have completed, right? Now tell me, which was the first part that was added in the original Constitution through an amendment? Which was the first part that was added in the Constitution through an amendment, in the original Constitution through an amendment? Part 4A, right? And remember, part 4A and 14A were included simultaneously. Okay, both were included through 42nd Constitutional Amendment Act, right? So they were included simultaneously. Do not forget this. The answer can be both A and B, that is part 4A and part 14A. So with this, what you understood? That whenever we start feeling that we are champion of polity, then comes another question from polity. Okay, so the day you feel demotivated, contact me, but the day you are feeling over motivated, do contact me. Okay, because we should be at a ground zero. Remember, polity is the most important topic and it is the most complex topic. Is it clear? Very good. Now we will be beginning with part 3 of the Constitution. What does it deals with? Part 3, it deals with fundamental rights. Articles 12 to 35. Now the questions in prelims are becoming conceptual. So what do you or why these rights are called as fundamental rights? Why these rights are called as fundamental rights? Highest protection, they are essential. Existence, very good. Guaranteed by Constitution, very good. And if these all three options are there, which will be the most appropriate? Highest level of protection, guaranteed by the Constitution. So remember, the word fundamental rights represent something important. Otherwise, in the USA, they are called as Bill of Rights. Right? So this is adopted from the United States of America, where the USA call it Bill of Rights. Now we adopted so many things, we did not change their name. Like we adopted parliamentary system from Britain, we call it Parliament. We adopted judiciary from USA, Supreme Court, we call it Supreme Court. We adopted the office of governor, we called it governor, but we adopted Bill of Rights, we call it fundamental rights. Don't you think that is an important question to be asked? So these are not called as Bill of Rights but fundamental rights. That means we need to understand this basic definition of fundamental rights. Now there are rights. I am not going into the details of it, what are rights, because that is the part of the main topic. I am just discussing that there are rights which are called as human rights, right? Or we will say bigger approach, there are natural rights, okay, that are provided by the nature. In the nature, the humans have certain rights that are called as human rights. Now these human rights have to be protected from by or have to be protected through a constitution, right? So citizens, they have rights that are called as civic rights. Heard about this? Civic rights. So there are civic rights. Now let us consider this as 1, 2, 3. Where will you put fundamental rights? Fundamental rights are bigger than natural rights. They are between human rights and natural rights. They are between human rights and civic rights, or they are narrower than civic rights. Narrower than civic rights. Above civic rights and before human rights. Now what will be the above civic right means 2. What will be the answer? 1, 2 or 3? Good question. Very good. So it will come on 2, because fundamental rights are those rights which are not only provided to the citizens, they are provided also to the aliens, right? It means they are more better, or they are broader than the civic rights. At the same time, these rights, they are provided by the fundamental law of the land. They are not only guaranteed, but they are also enumerated in the fundamental law of the land. That is called as the Constitution of India. That is why they are called as the fundamental rights. It means the rights which are mentioned and guaranteed by the fundamental law of the land, they are the fundamental rights. Because there are other rights also in our constitution. There is a question that right to vote, it is what type of right? It is also a right. Right to property, which is what type of right? It is also a right. But they are not in the fundamental rights. That we are very clear about it. What they are, we will be discussing. But they are not in the fundamental rights. We are clear about it. It means only those rights which are provided by the fundamental law of the land under part 3. Only those rights will be called as fundamental rights. Is it clear? Understood? Not the civic rights, not in the rights. The part 3 rights are the fundamental rights. Otherwise, there are so many other rights also. Are we clear with this? Very good. We know we have adopted it from the USA. We know that these are the rights that are establishing the idea of which type of democracy? The basic political democracy, right? This is very basic. They are establishing the ideas of political democracy. Yes. Now, there are how many types of fundamental rights? This is another question. Okay. So, what type of fundamental rights do we have? How many types? Tell me. 1, 2, 3, 4, 5, 6 or 7. How? Teaching polity does not even know there are 7 political rights, right? What at faculty am I? Right? Now let us discuss. Because there is a doctrine of eclipse, you cannot remove it. When you open your books, you mentioned 7 types of fundamental rights. You find a mention of them. Why? There is a reason that even if it is not functional. For example, you go to a party, right? Your roommate is not there. Your party roommate says, bring the meal for me also. Yes, your party and your friend is not there, but that member is still your roommate. Similarly, there are rights. One of the right is repealed, but that will not be taken out from the family of rights. You need to know that it was repealed. Then only you can answer the question that right to property at Amendment 44th, it was repealed. Otherwise, we will not study about it. Is it clear? Very good. So, first is right to freedom or right to equality. Equality. See, we will be studying fundamental rights for 2 reasons. First, definitely question will come. It means if you go to the exam center, you see the question paper, you don't find a question of fundamental rights, what will you do? Run. Because you are in the wrong exam center. Run very fast. Because fundamental rights will be their questions. Second, you are citizens of India. You should know what are your rights. Clear? So, for 2 reasons, these are very, very important. Well, right to equality. From which article to which article? 14 to 80. You must be thinking, some of you, why this is very basic, why are we discussing it? So, I told you 2 words yesterday, trust and patience. Right? So, something important will come out of it. So, right to equality, then right to freedom. Yes or no? Very good. From article 19 to 22. 18 cannot be twice, right? Then third is right to exploitation. Against or to? Against exploitation. From articles 23, 24. Then right to freedom of religion. From article 25 to 28. Then we have cultural and educational rights. Article 29 and 30. Then we have right to property. Article 31. Then we have right to constitutional remedies. Right? Article 32. Simple. Very simple. Only these are the fundamental rights. Now if a question comes, Article 31A is a fundamental right. True or false? Tell me. What will you do? You will do maths. 31A means is in the number line from 12 to 35. Well, so simple question. True. Maths says true. But which subject are we studying? Polity. Article 33 is a fundamental right. No. 34, no. 35, no. Only these are the fundamental rights that the Constitution has provided. Rest everything is a mahal around it. Right? Clear? So this is the way you must have watched Pushparaj, Pushpa. Right? Only one dialogue was famous, Mai jhukega nahi. Everything was a mahal around it. Yes or no? Same thing, these are the only fundamental rights. Other articles are only the provisions related to the fundamental rights. Now, this is right to property. I have written it with other color, you know it. Why? Because it is at present not in activity. But if in future government brings or the parliament brings right to property, which article will it be? Article 31. Okay. So you must know what is Article 31. It was repealed through which Amendment Act? 44th Constitutional Amendment Act, 1978. Simple. These are the types of rights. Yes. They are only telling that from, for example, if you are reading a chapter, yesterday you were not there, na, first class, that is why you are not able to get it. Parts are only telling which article to which article are dealt in this, right? Sometimes in the books also, the book says this chapter to this chapter, but in that in between one advertisement is also there. Yes or no? Purified water for students, have water like home. Sometimes in your magazines you have this, but that page is also mentioned in the chapters, right? Because it is about the part. Not necessarily it is providing the right. Is that clear? Only these are the rights. Rest are the provisions related to the fundamental rights. And we will be discussing each and every provision. Are we clear with this? Very good. Note this down so that you know only which are the fundamental rights. Other than these are the exceptions or the provisions related to the fundamental rights. Confusion? What you did not get? Control Uday. Control. Patience. Today, if by 8:30 you did not get it, I'll sit with you and explain it. Okay? Just wait till the end of the class. That is why the beginning of the movie is most important. You'll get it, don't worry. Yesterday we made the mahal and we'll understand it today. Done? Everyone has noted this down? Very good. You all seem amazed when I said 8:30. You all were surprised? No? We'll complete the substantial portion and let us see when we'll go home, right? Because exam is round the corner. Clear? Done? Note it down? Everyone has noted this down? Very good. Now, the rights are having certain features. The fundamental rights are having certain features, and question may be there that what are the features of the fundamental rights? So what are the features of these fundamental rights? The fundamental rights, the first most important feature that they are provided by the fundamental law of the land. Not everything is in the notes. Then otherwise we will not come to the class if I give everything in the notes, right? So, fundamental law of the land. These rights are available only to the citizens, true or false? False. The rights, some of the rights are available only to the citizens, true or false? True. And that means that sum is also very important. Now, the rights are available to both citizens and aliens, right? Rights are available to citizens and to aliens, but certain fundamental rights are only available to the citizens. Which fundamental rights are there? 15, 16, 19, 29, 30. These are the fundamental rights which are available only to the citizens. 15, 16, 19, 29, 30. Clear? All the other rights are available to citizens and aliens. Is it clear? Understood? Now, this much, because that will be a very high level question, it will not be asked in UPSC. This much is sufficient. These rights are available horizontally. Some are available horizontally, some are available vertically. Horizontally and vertically. Now, vertically means you have these rights from the state, right? Horizontally means you have these rights against your fellow citizens also, fellow human beings also, fellow members of this country also. It is horizontally, we all are at the same platform. So, we can demand our rights at the horizontal level also, and vertically means we can demand it from the state. So, rights are both. For example, abolition of untouchability. It protects not only from the practice of untouchability by the state, but also by any other individual. So, it is available vertically and horizontally both. Now, the some rights are self-executory and some are executed through laws. So, some are self-executory. For example, there is a prohibition on discrimination on the grounds of religion, race, caste, sex or place of birth. No need to have a law for it. It is just prohibited. But right to education you can only provide by passing a law, and that is why law was passed, Right to Education Act, right? So, wherever in the right you find the term written that the state will determine or in accordance with law, that right will be executed by a law. That right will not be self-executed. Is it clear? that right will not be self-executory, but the rights which are not mentioning that it will be applicable by the state, or it will be determined by the state, or it will be determined by the law, that are executory, self-executory. Are we clear with this? Very good. Rights are not absolute. They are not absolute, but are qualified. It means, do we have reasonable restrictions in the fundamental rights? Yes. So it means they are not absolute. There is only one fundamental right which is considered to be absolute. That is Article 17. Okay. Article 17 can be considered as absolute. But our right to education can also be absolute. Right to education can also be absolute. Why? Because there is no limitation in the right. The limitation can be in the act made by the state. Because untouchability is also saying in accordance with law, right? And in accordance with law, the social boycott is not a untouchability. Supreme Court has said in a judgment that the social boycott is not a practice of untouchability. Similarly, other rights can also be qualified. So the Constitution has made Article 17 absolute, but it can also have certain restrictions, but not through the Constitution, but by law. Okay, but for the simple thing, the rights are not absolute, they are qualified, except Article 7. Is it clear? This point is clear? So the rights are not absolute, they are qualified. Then, yes, beta. Fourth point. Fourth point is saying that the rights are self-executory. For example, you read the right abolition of titles. Do you need a law for abolishing the titles? No. Article 18 itself is executory. But you read the article says that prohibition of untouchability. How will you prohibit? By law? Yes. So some are complete in itself. It means you do not need a law for the execution of those rights. Some are executed through laws. Is it clear? Very good. Now you know that they are not absolute, they are qualified. They can be suspended. They can be suspended. How they can be suspended? In accordance with Constitution. They can be suspended in accordance with Constitution. And the Constitution allows the suspension of fundamental rights and its enforcement under Article 358 and 359. So under 358 and 359, you see the suspension of fundamental rights. Under Article 358, Article 19 is suspended, and under Article 359, the enforcement, that is Article 32, is suspended. Clear? Then we'll be doing emergency, that will be revised again. Now, some rights can be restricted by the Parliament. Can be restricted by Parliament. For armed forces, intelligence agencies, etc. Right? Armed forces and intelligence agencies, etc. It can be suspended. Clear? For example, when you will become a civil servant, right, you cannot have the same rights that you have right now. You cannot have the same rights, because at that time you are a part of an agency whose rights can be suspended. Similarly, if you join armed forces, your rights will be suspended to an extent. Very simple example of it is that the officers of armed forces, they are not allowed to have social media accounts now. You know that this is a norm, but using social media is your right to freedom of speech and expression. Yes or no? Otherwise, where will you make the reels of Kacha Badam? It is a freedom, but if you are a member of armed forces, no Kacha Badam. Now, will you consider it as a right? Will you consider it as a right or a limitation on rights? Very good. Sure? Pakka? Very good. And this is Article 33. So, Article 33 is a fundamental right? No. It is to a limitation on fundamental right. Now, it is becoming a little clear. Now, this question may come. Previously, we used to say when we were teaching that this question will never come. But now this may come. That these rights can be suspended during martial law. These rights can be suspended during martial law. So, will you consider as a fundamental right? Will you consider it as a fundamental right that these rights can be suspended during martial law? Tell me. Will you consider it as a fundamental right? No, and this is Article 34. That the fundamental rights can be suspended during martial law. Who can say that there is a martial law? Who can announce the martial law? Who can announce the martial law? President or Parliament? President or Parliament? Tell me. Good question. Because Ukraine is under martial law right now, and our constitution also have martial law. Article 34. Very good. Now answer this question. That the constitution has defined martial law under Article 34, true or false? False. The constitution has not defined martial law, true or false? True. Very good. The term martial law is nowhere defined. False or true? True. Because we don't know. So there is a martial law. It will only be functional when it is announced by the Parliament. Okay. Now, who can make changes to the fundamental rights? Who can make changes to the fundamental rights? If you want the suspension of fundamental rights, who can do that? Tell me. If you want the suspension or you want the changes, who can do that? Parliament? Parliament. And what about the state legislature? Very good. So, only Parliament, not Parliament, only Parliament can amend or elaborate or make any law with respect to fundamental right. Will you consider it as a fundamental right? Tell me. And this is which article? 35. This is Article 35. Right? So now you know that why they are not considered as fundamental rights, but you all know that they are the part of the fundamental right. Parliament by a law. Parliament by law. Is it clear? Yes, beta. No, AFA is not a martial law. AFA is just a law that is giving these certain special power to the armed forces in the disturbed area. But the martial law will be everywhere in the country. Now you will ask, what is martial law? I don't know. We don't want to know. Do you want clarity about martial law? Ask Ukraine. Don't ask that in India, because we don't want any such application of martial law. The way we did not want to know what is a lockdown, right? We did not want to know. But the students of civil services, they have been studying disaster management. They knew what is NDMA, but they did not want to be a beneficiary under NDMA. Similarly, we don't want what is the martial law. But now you know who can announce the martial law? Parliament by a law. It is given under part 3 of the Constitution. But is it a part of the fundamental right? No. Clear? The features of the fundamental rights are clear. Someone in the online class is asking about the 5th feature. You want to note this down? 5th feature is rights are absolute or qualified. It means the rights are not absolute, they comes with the reasonable restrictions. Reasonable restrictions means, for example, you have right to freedom of speech and expression. That does not mean you will say everything. Okay? You cannot say everything until you are not Kangna Ranaut. Then you are allowed to say anything. Okay? Because then you will be Padma Shri. Right? Otherwise, there are reasonable restrictions on the fundamental rights. Article 24, it is absolute. In the books they are saying. Other than saying where it is written as according with the law, all are absolute. That is what I explained. Wherever in the right it is written as accordance with law or the state may determine, the right is absolute because the limitations are not there in the right. We will discuss slowly. 17 only. Only 17. No option will, other option if it's there, then read that question very carefully. Okay? Read that question very carefully. It's not that only 17 is absolute, but in general 17 is absolute. As per the books. Clear? Because what happens in the books, there are additions. And additions come with the question that has come in UPSC. Right? This is how the new additions are coming. But we have to ensure that we do not have to purchase that new edition because we are in the academy by then. Are we clear? Yes or no? Very good. Not this much low energy. Give me more energy. Yes? ऐसे नहीं बोलो हाँ हाँ हम तैयार हैं. Say you are a civil service aspirant. हाँ ऐसे हाँ हाँ हम तैयार हैं. Say. Very good. Because now you are reading your fundamental rights. Everyone has noted this down? Is there anyone who wants to note this down? From 1 to the others, we are having the fundamental rights. Yes, beta? No, any fundamental right. For example, any fundamental right you see, for example, you see the law with respect to the application of, let us say, right to education. You want to see the application of the Protection of Civil Rights Act. You want to see the prohibition of child labor. You want to see that a law which is saying that there will be the Commission for Minorities or the Minority Education Institutions. Anything related to the fundamental rights, only Parliament has the power. No other body have the power except the enforcement power that are with the courts. Clear? Horizontal. It means, for example, if I am violating a fundamental right, am I the part of the state? Now the question comes, what is state? Confused? Very good. So tell me what is state? Central government, state government, municipal boards, PSU. Very good. Anyone else? No? Who governs the land? Somewhat confusion we have. Do not worry, we have Article 12. Our forefathers knew that when we are preparing for prelims, we'll have this confusion. So they knew that what is the state, the students will be confused. So, for reference to the word state in this fundamental rights topic, whatever is mentioned in Article 12 will be considered as state. Is it clear? Now, whatever is mentioned here, it is state. Now, if my name is mentioned here, then I will be a part of the state. Very good. If my name is not mentioned here, I will not be a part of the state. Can I violate your fundamental rights? Yes. If as a state I am violating, so you are a citizen. You are above the state. So your rights are violated. A body subordinate to you. Your rights are violated, body subordinate to you. So vertically your rights are violated. If I am not part of the state, I am also citizen, you are also citizen. If I am violating your rights, horizontally your rights are violated. So protection, two fundamental rights are horizontal violation and vertical violation. Are we clear? Yes or no? Very good. Now we have this confusion, but the confusion will not arise, because if you do not read Article 12, you read Article 15, that the state shall not discriminate. You read Article 16, the state shall not discriminate. Article 18, the state shall not provide. But you don't know about whom we are talking about. Yes or no? But Article 12 tells you that do not worry. We are giving you the understanding. First, the executive and the legislature body of the union. Union executive. That means President, Vice President, Prime Minister, Council of Ministers and Attorney General. Union legislature, it means President, Lok Sabha, Rajya Sabha. They are the part of the state. Second, the state executive and legislature. The state executive and legislature will be the part of the state. Then the municipal and local bodies. Now will Panchayat be the part of this definition of state? Yes, because it is a local body, right? It is a local body. Very good. Any authority which is not 100% government, but it is having more than 50% stakes of the government. That means a body which is a public sector undertaking. Simplest example is DMRC. Now, for example, you are going, okay? You are going and very coolly you are walking on the railway track, okay? Very coolly. And you are given a very nice beating. Now, when you are going to the, because then you will take the same metro, go to the Supreme Court, and you say my rights are violated. You know that it was violated by the state, because public sector undertaking also under the state. This is what is given under the Constitution. But Supreme Court has elaborated it. Supreme Court has also given this statement that, or this judgment, that if a private entity is working on the government contract, okay, for example, your Aadhaar card was made by Tata Group. You know that? Aadhaar card was made by a private entity. Now, while you are getting your Aadhaar card, you have to get your picture clicked. Now, you wanted a good picture to be there in Aadhaar, so you had a brawl with the person. Now, they have also again given you a good beating. Now, will you complain against the state or a private entity? State, because it is working on the government contract. Otherwise, why will you go there? You could have gone to a photo shop where you are getting a picture clicked. Is it clear? So, a body working on government contract, even if it is a private entity, it is considered as a state, but not as per the Constitution, as per Supreme Court judgment. Clear? Very good. So, as per Supreme Court, private entity working on government. Are we clear? This is that, yes. Private entity. Word is may be considered as a state. The Supreme Court said the BCCI may be considered as a state. It is not necessarily state. Okay? It is a private entity getting all the benefits representing Team India. Okay? Article 12 is clear. Do we have any doubt from Article 12? Yes or no? It may be considered as a state, but it is not a state. It is a private entity. Okay? But they wanted it to be considered as a public authority. But they said it may be considered as a state, but right now it is not. It is a private entity because BCA simply said will not represent them. And BCCI means maximum shareholders in ICC, right? And can you have the situation no cricket for some time, right? Very good. So this is clear. Article 12 is clear. Let us go to Article 13. Now I have used this term that it will be applicable in accordance with law. Right? It will be, and you know, any law cannot violate your fundamental rights. You know that? Yes or no? Yes. But what is the meaning of the word law? I am saying any law which is violating your fundamental rights, that law will be declared as null and void. But what is the meaning of the term law? Why confused? Article 13. Not constitutional makers were very reader friendly. They said we know students will be confused, so they have given Article 13. Now you know Article 12 and 13 why they are not fundamental rights, because they are explaining the fundamental rights. I told you Mohol. Right? So Article 13, it simply says what I just said, that any law, if it is violating your fundamental right, that law can be declared as null and void by the courts of the land. Right? So here we are confused that any law violating fundamental rights can be declared as null and void. Now, what is the meaning of the term law? Let us identify. What do you think is the term law means? What is the meaning of the term law? Simple. Any law passed by the legislature. Yes? Any law passed by legislature. Which legislature? Union or state, both? It can be union legislature, state legislature. Very good. Any ordinance passed by president or governor. Ordinance passed by president or governor. Clear? Third, delegated legislation. Delegated legislation. Okay. Fourth, custom having force of law. Having force of law. That will be considered as, they will be considered as the definition of term law. Is it clear? Custom having force of law. Now, there is a, have you heard about the thing called as Stridhan? Stridhan. No. Dowry is Purush Dhan. We are talking about Stridhan. Okay? Dowry is given to males. Stridhan means the jewelry that is given by the bride's family and the groom's family, that will belong only to the bride. This is a custom. Very good. If the groom's family wants to take that, the lady can go to the courts also, because even though it is a custom, but it is having a force of law. Another example, because there is a recent judgment of the Delhi High Court only, that the bride or the daughter-in-law does not have the right to stay in the house of in-laws if she is ill-treating them. Right? That means it is a custom that the bride must live with the groom's family, and it is considered as a law. So that is the custom having force of law. But if any such custom is violating fundamental rights, then it will not be allowed. Example, Khap Panchayat saying girls should not wear jeans because they are, English word of bigadana. So it is violating fundamental right, because right to wear anything is your fundamental right. Is it clear? Very good. Under which article? Right to wear anything, because Karnataka High Court judgment came today. 21 or article 25? Because hijab judgment just came today. 21. Why? Because right to wear, you are a citizen or an alien. It is a right to life, because it is a part of a personal liberty. Is it clear? Very good. Are you clear with this? No doubt? Sure? Say pakka no doubt. I want to hear from your mouth. That it is not an essential practice. But we are saying right to wear. I did not say the word hijab. Understood? In the questions, do not read what we have in our mind. Otherwise, this will be wrong. Now, no doubt pakka? Very good. Anyone please explain what is delegated legislation?
The state legislature has a delegated power to panchayat some function.
Legislative power panchayats do not have. Where will they legislate? In panchayat band, but there the kirtan is going on?
Union is delegated.
No. And you all said that you don't have any doubt. So tell me please, what is delegated legislation? This is a UPSC question also about delegated legislation. Very good. Law making power delegated to the executive. For example, the law making power with respect to the education is with the parliament, but the parliament has delegated it to the Ministry of Education, and that is why we have Ministry of Education, National Education Policy 2020. We have it. That is a delegated legislation, because it is having a force of law. This delegated legislation is also called as subordinate legislation. Okay, and there was a question in UPSC that which committee will deal with the subordinate legislation. An option had committee on delegated legislation. So what will be the answer? When you know the names, it is very easy. So delegated legislation meaning you have understood. Other name of delegated legislation you have understood. This is consisting of rules, bylaws, other regulations also. For example, Citizenship Act amendment has been passed, but the rules are pending. So the rules will be made by the executive. They will be called as the delegated legislation. Clear? So write the other name for delegated legislation also. That is subordinate legislation. Done? Very good. Now, it is saying that any law, if it is violating the fundamental right, that will be declared as null and void. But by which power the courts will declare that as null and void? What power are they having? Judicial review. It means this power is generally having an implicit meaning, which is called as judicial review. Okay, it is nowhere mentioned in the constitution. So the question may come that the term judicial review is nowhere mentioned in the constitution. True or false? True. The term judicial review cannot be interpreted from the constitution. True or false? False, because it can be interpreted. This is implicit. It is implicit in the article 13. Are we clear? Very good. This is article 13. Clear? Very good. No doubt? Pakka? Tell me. Just say pakka, no doubt. Pakka? Very good. Now, will an constitutional amendment be considered under the definition of law or not? A constitutional amendment, will it be under the definition of law or not under article 13? Think and tell me. Constitutional amendment, will it be under the definition of law under article 13? Yes? Yes? Pakka? Then how come there are amendments? Right to property had been repealed. Huh? Let us go to Supreme Court. Bring back our right to property. We'll divide our rooms. Right? Because when we are getting right to property, we'll at least have some share. Because you are saying any law means any amendment which is violating. Why it took away our fundamental right? It will be declared as null and void. Tell me. A constitutional amendment is there under the definition of law or not under article 13? Good question. So, the term law, someone is giving the right answer. Not to yourself, to me. I know someone is giving the right answer. So, the term law is there under the article 13, but there is a doctrine of basic structure. Because the parliament has the power and procedure to amend the constitution. So, there is a doctrine of basic structure that only those amendments which are affecting the basic structure, they will be declared as null and void. Otherwise, they can change the structure. Are we clear? Yes or no? Now we have completed article 13. Okay. Do we have any doubt in this? Now let us begin our fundamental rights, because till now we are just making the mahal. Now when you hear the word state, where will you go directly? Article 12. Yes. Bill is not a law. No. Amendment is an act. Amendment word means change. Okay, we will be doing constitutional amendment, do not worry, we will be discussing that. But bill will become an act, amendment bill will become an amendment act. Bill making changes in the constitution is called as the constitutional amendment bill. Bill just making any change, just bringing anything new is called as a bill. Bill making changes in the consolidated fund of India for money, money bill. Clear? When it is passed, act. Are we clear? Yes or no? Very good. So let us go to article 40. It is right to equality. See, for prelims, I have given you handouts because otherwise you will feel we have not got the material. But whatever I am writing on the board, just revise that, that will be sufficient. Okay, just revise that before the day before the examination, that will be sufficient for you. Okay, because in prelims not everything will come, only few things that needs the conceptual clarity, that will come. So right to equality from article 14 to 18. Article 14, what does it say? What does it say? Equality before law and equal protection of law. Simple. It says equality before law Unequal protection of law. Equality before law and equal protection of law. Now, from where we have taken equality before law? Let us first understand from where we have taken. Then we will discuss what does it mean. From where? We have taken it from UK and we have taken it from USA. Okay. Now, what is the meaning of word equality? We discussed that yesterday. What is the meaning of equality? Absence of privileges. It means when it comes to law, no one will be having any privilege. Everyone will be equal in the eyes of law. No one is above law. Law is supreme. Right? That is the meaning of equality before law. Equal protection of law means when the people are being protected through the equality, there can be various groups that are divided. For example, we gave the we were discussing the example of Bhandara yesterday. Yes. So when we are in the line of Bhandara and someone is coming with a bag, okay, we found that it is violation of equality. Yes or no? But when a senior citizen, an old lady is coming with a bag, will you feel she is violating equality? No. Now, at that time there is a separate line for senior citizens. Will you think that it is violating equality? No. If there is a separate line for children also, will you think it is violating equality? Very good. But if it is a separate line for, let us say, the people of the same colony that is organizing the Bhandara, will you feel they are violating equality? Right? Because likes should be treated alikes. The groups should be divided in a same way that the people are similarly situated. So, equal protection of law means the people who are alike can be given protection in a same manner, in a similar manner. Those people do not necessarily have to follow the equality. Clear? Let me give a simple example, the simplest example. In India, everyone is equal in the eyes of law. If you want to catch a train, where will you go? Railway station. If our Prime Minister has to catch a train, where will he go? Yesterday, in the previous week, he met school students on Sunday. Yes or no? He met few school students going to school on Sunday in metro. But that metro did not come to his house. He went to the metro station. We will also go to the metro station because equality before law. Is it clear? If he has to fill the nomination paper for the election, you have to fill the nomination paper for election. The election commission will not come to your house. You will go to the district office, returning office, or the office of the returning officer, right? Equality before law. But in that train, there are the seats reserved for ladies because equal protection of law, right? Are we clear with this? So, this is taken from UK, this is taken from USA. This is the negative right because you are taking someone's privileges. That is why it is a negative right, and it is a positive right. It means you are giving certain positive discrimination under this right. Clear? Yes or no? I think this cannot be more clearer than this, because when we read Article 14 we are confused, right? Now we are crystal clear. Very good. So, answer this statement that article or equality before law is a concept same as that of rule of law. True or false? True. Equality before law is a concept same as that of rule of law. True or false? False? False. What is wrong in this? It is taken from UK rule of law evidency. What is the problem? Both. Okay. Answer is correct. It's false. But assertion is correct. Reason is not. So, tell me. It is not rule of law because the first simplest basic thing, because in the UPSC preparation we always lose the basics, and the most simplest thing is the answer. had it been rule of law, why will you call it as equality before law? You'll call it rule of law. When the parliament is called as parliament, prime minister is prime minister called as prime minister, governor is called as governor, yes or no? Why will you call it equality before law? We'll call it rule of law. Simplest answer. Because equality before law is only a subset of rule of law. Rule of law is having one more extra provision. Rule of law says no, everyone is equal in the eyes of law. No one is above law, and there is no source of authority for making laws. In India, do we have source of authority for making laws? What do we call it? Parliament. Constitution. Source of authority, yesterday, fundamental law. Yes. So in India, we have a source of authority. In UK, do they have a written constitution? No. So they follow rule of law, but we follow equality before law because we have a source. Clear? So the question comes that equality before law is same as that of rule of law, true or false? False. Equality before law is a subset of rule of law, true or false? True. Okay. You can write it if you want to write. This can be a note that equality before law is not rule of law but a subset of it. Equality before law is not rule of law but a subset of it. Someone is asking online class, please explain CA can be considered law or not. But CA or CA by this she means Constitutional Amendment Act. Okay. So Constitutional Amendment Act means it is considered as a law. Okay. Given that it is, or it will be considered only as a law if it is violating the basic structure. Okay. Otherwise, it is out of the jurisdiction, and it was given under the Keshwan and Bharti case. Clear? This is clear to you? You have written equality before law is not rule of law but a subset. Understood? Shall we proceed? Yes, no? Article 14, crystal clear. Who gave rule of law concept? A.V. Dicey. That is a very simple thing. This you have noted? Everyone noted this down? Very good. Now when we have completed 14, where will you go? 15, obvio, right? Now, what does Article 15 says? What does Article 15 says? Prohibition of discrimination on the grounds of Tell me. You were just you were okay. Tell me, what is Article 15 saying? On the grounds of race, caste, sex, class, language, sex, place of life. Read, you all have notes, read it. Not language is also not there, class is also not there. Right? And how many times we have read Article 15? So many times. Because when we say that we will be able to attempt 90% questions, we have to take a microscope with us. Yes. Now the Article 15 says that the state shall not. Right? This right is available to all or only Indian citizens. 15. Very good. The state shall not. So what is the meaning of the term state? Article 12. Okay, it is a hyperlink. Click it, go to Article 12, read it. Right? In your mind, do that. Now Article 12 says state shall not discriminate against any citizen. This is what is citizen? It shall not discriminate against any citizen on the grounds only of. On the grounds only of. 5 grounds are only mentioned. Religion, race, caste, sex and place of. In your notes, I have given you one slide. Only these 5 words are written in that slide, right? Because only these are the grounds on the basis of which the state shall not discriminate. Okay. It means, can the state discriminate on the grounds of class? State can discriminate on the grounds of class. Language, yes, it is allowed. Okay, because only these grounds are not allowed. Now, it means this right is vertical or horizontal? Vertical, because only state is limited. Right? So it means we are allowed to discriminate. But it says this is not 15 only, this is 15(1). Any person shall not discriminate against the citizen on the grounds only of religion, race, caste, sex, place of birth while visiting a public place, public well, hotel, restaurant, then it will not be violated, right? So only on this ground. Okay. Sometimes student, they read this much only, then they go to OYO, they say no, you are not allowed. They say article violation, article 15, hotels and restaurant is written, but age is allowed. Age is allowed. Any person can discriminate on the basis of age. Is it clear? Are you clear with this? So hotels is mentioned, do not worry, but age is not mentioned. So the public, because there had been a controversy, a lady was wearing a sari and she was not allowed to enter a restaurant in Delhi, right? Because dress is not mentioned. If it was mentioned, then it was a violation, right? It is not mentioned. Are we clear with this? Both. Okay, both. Is it clear? It means there shall not be any discrimination. Now you say, but our family are saying, no, we will not allow anything outside religion, outside race, outside caste, outside sex. No, outside sex they allow. Okay. And place of birth they don't allow. It means in India we have a culture of religion, endogamy, race, endogamy, caste, endogamy, heterosexual, and place of birth, endogamy, right? But you cannot go against the or against them in the Supreme Court, because they are not stopping you from doing whatever is mentioned in Article 15. Okay, so whatever is mentioned in 15(2), only that is a fundamental right. Others are not fundamental rights. Is it clear? Yes or no? Very good. 15(1), 15(2) is clear to you? Yes, no? Doubt? No doubt? Very good. Now, since you are a child, you always wanted to go inside a girls' school, right? Yes or no? Yes, everyone is saying yes. So, now you know it is a public place. It is a public place and there is a discrimination on the grounds of sex. What do we do? Go to Supreme Court? We'll wait till tomorrow because it is closed now. We'll wait till tomorrow. We'll go to the Supreme Court, take a metro. Yes or no? We'll assemble, take chips also. Eat. Yes. But there is Article 15(3) also. Oh no. Article 15(3) says that nothing in this mentioned in this article can stop the state to make provisions for women and children. Nothing in this article can stop the state for making provisions for women and children. Is it clear? Now tell me this answer. To have special provisions for women and children is a fundamental right. True or false? To have special provisions for women and children is a fundamental right. True or false? False. Why? Yes. State is not stopped you to make any special provision, but you cannot go to the state, let's make a provision. I am a child. Make that Cadbury world. Kitna maja aaye re. You cannot do that. Is it clear? Because nothing can stop the state from making such provisions. Is it clear? At the same time, there are articles 15(4) that says that nothing in this article can stop the state for making any provisions for the welfare of scheduled caste, scheduled tribe, socially and tell me, socially and yes? Which one? the question that I asked. See, that it is not a fundamental right of women and children to have special provisions for them. Okay, it's just that the state cannot be stopped from making. Clear? So it says that there has to be special provisions. The state cannot be stopped from making special provision for the welfare of scheduled caste, scheduled tribe, socially and economically backward classes. True or false? Educational is there. If economically was there, there was no need for the which amendment act? 103 Constitutional Amendment Act. That was not needed because it would have been already there. So it is educationally backward classes, right? Then 15.4, after 15.4, 15.5, it is also same. It is also same, right? Only addition that they can have special provision for scheduled caste, scheduled tribe, SC, BC for educational institution. Okay, for educational institution. Are we clear? And there is 15.6. It provides the rights for the reservation for the economically weaker section. So nothing in this article can stop the state from making any provision for the economically weaker section. Yes, beta? Beta, 4 means in general, 5 means only particularly for educational institution. Okay, particularly for educational institution. Yes, beta?
15, 4 and 5 and 6 are not the obligation.
They are the power that the government state have.
That is not the obligation. That the state want that we will do it. So they are the fundamental rights still.
They are the provisions of the fundamental rights. It means your 15, 1 and 2 are the fundamental right and rest are the reasonable restrictions. That means they are not absolute. 15, 1 and 2 are not absolute. 3, 4, 5, 6 provide the restrictions. Okay, understood? 15 is clear to you? Any doubt? Very good. After 15, what will come? Article 16. What does Article 16 says? What does it talks about? Public employment. It is available for all or citizens only? Citizens only. Now who will provide public employment? Government. State. State means 12. Right. There is a reservation provided 75% by the Haryana government. Yes. So the chances of this question are high. So the reservation provided by the Haryana government, okay, comes under Article 16. But Haryana government has done. Maharashtra also did that. Karnataka also have such provisions. That is in private sector. It is public employment. Okay. The reservation, 75% reservation is in the private sector for the Haryana state. But Article 16 talks about public employment. Public employment, employment under the state. What do we understand by the state? Is it clear? Understood? So Article 16 means the equality of opportunity public employment. This is the first article. 16. Then there is 16.2. That the state shall not discriminate while providing public employment on the grounds of how many grounds? Same as 15. Yes, read it. And one more, right? 7 are there. So if the question comes, does the same reasonable restrictions are there or the restrictions on the state not to discriminate? No, 16 has more restrictions. So the state cannot discriminate against the citizens on the ground only of religion, race, caste, sex, place of birth, descent and residence. Are we clear? 16.2 is clear to you? So there are 7 grounds. It means state employment can be discriminated on the grounds of language. Yes, it means if the, let us say, state of Kerala says that you are not allowed to give the exam until unless you know Malayalam, will it be a violation of Article 16? No. But if they say you will not be allowed to give the exam because you are not a resident of Kerala, that will be a violation of Article 16. That is why wherever you know the language, that government exam you can give. Yes or no? That is why the aspirants do the Bharat Darshan in this way. Wherever they know the language, they are allowed to give the exam because of equality of opportunity in the public employment. Is it clear? Very good. Then there is Article 16. Now, there is a criteria that there is no discrimination on the grounds of residence, right? But can the state discriminate on the grounds of residence? Can there be a discrimination on the grounds of residence? Yes. Example, Andhra Pradesh, right? Where? It means there can be a reasonable restriction. Who can give that reasonable restriction? Parliament or state? Parliament or state? Because there can be a question that the state can make residence as a criteria for providing public employment. So it is not state, it is parliament. Okay, so in 16.3, be very clear, underline it, make a box. Make a box that there is a criteria, but this criteria can only be provided by the parliament. Can state legislature provide that? No, otherwise every state will make residence as the criteria. See, logically also we have to study. If a state is allowed to provide it, do you think any state will leave that opportunity? All the states say yes, residence should be the criteria. Now, do you know that there are reservations on the basis of caste also in the public employment? But here it says it should not be any discrimination on the grounds of religion, race, caste, sex, place of birth, descent or residence. And you have seen the provision of reservations in almost all the factors, right? So, is it a violation? No. 16.4. 16 is not over. Article 16.4 is also there. It says that the state can make provisions for the welfare of backward classes. This is what it is saying. Now, this can be made by the state or the parliament. Here it says state or parliament. State. Anyone can make. That is why every states have their different reservation criteria. Some states provide reservation to women. Some provide reservation to freedom fighters. Some provide reservation to the defense dependents of the defense forces, right? Some provide reservation for the, let us say, minorities. Some provide reservation on the basis of the other criteria also, right? Ex-servicemen, because the state can make any provision for the welfare of backward classes. Is that clear? Very good. Now there are two articles, Article 16.4a and 16.4b. Okay. Right now, if I will teach them, we will not come from tomorrow onwards because they are difficult. Okay. It is your responsibility when we have built our foundation that you will remind me that we have to discuss Article 16.4a and 16.4b. That is not that important because reservation in promotion, it is reservation in promotion. It's just that we need to know certain basics about it. Is it clear? Then comes Article 16.5. What does it talks about? It says that, for example, if there is a temple, okay, there is a temple, its priest, there are some temples that are managed by the state. Like Somnath temple, it was in news recently, it is managed by the state. Now, the person who is managing the Somnath temple will be considered as a public employment. Now, the state cannot discriminate on the grounds of religion. So, can a person from a different religion be a head priest of a temple? No, because of Article 16.5. Article 16.5 says, while appointing the head of the religious institutions and denominations, the criteria of the religion can be done away with. It means religion can be a basis of discrimination there. Otherwise, people will say, when a chief is not from the same religion, how can he or she preach? Yes or no? There is 16.5 and there is 16.6 that provides for the reservation for economically weaker sects. Are we clear? Yes, no? Very good. Any doubt we have till now? But a dissent means, for example, if you when will you become a civil servant? You will have a family in future. Now you are a civil servant. Do you want your child to become a civil servant? Yes. So that will be through the dissent, that you are also civil servant, your child is also a civil servant. But the state cannot discriminate positive or negatively. It means, okay, your parents are civil servant, go directly for the personality test, no need to give prelims. If it is there, it is a violation. Or if a family is having a criminal and the child wants to have public employment, can then the state discriminate? No. There is an example of Afzal Guru. He was given capital punishment and his son, he scored good marks and it was in news. Now if he wanted public employment, he could have had, even though his father was given a tag of a conspirator against the state of India, but the child will not be having any discrimination on the basis of dissent. Is it clear? It means criminal cases will be of the person only that will be considered. Otherwise, no discrimination. Understood? Very good. Any other doubt? Now after 16, what will come? Article 17. Very simple. What does Article 17 says? What does Article 17 says? Article 17 says abolition of untouchability. Abolition of untouchability. Now, very simple question. Answer this, true or false. The term untouchability is nowhere defined in the Constitution. True. Very good. So, because the Article 17 says that there has to be the prohibition of untouchability and it will be punishable in accordance with law, right? And in this regard, the prohibition or the protection of Civil Rights Act, like prevention of or prohibition of untouchability, which was later on called as prevention of or protection of Civil Rights Act. Right. There is the act. Now answer this statement. The term untouchability is defined neither in the Constitution nor in the Protection of Civil Rights Act. The term untouchability is defined neither in the Constitution nor in the Protection of Civil Rights Act. False. False. It has been defined. It is defined in the Act. Very good. Read Article 17 from your notes. Write the notes in your notes. The term untouchability is neither defined in the Constitution nor in the Protection of Civil Rights Act. Mysore High Court has only given that what will not be considered as the untouchability. Mysore High Court said that it will be social boycott if it is not on the basis of birth. So that is allowed. Is it clear? Very good. Article 17 is an absolute right. Absolute right. It does not have any reasonable restrictions. One cannot say that untouchability in these grounds can be allowed. No grounds. It is totally prohibited if it is untouchability on the basis of the birth of someone into a particular religion, race, caste, sex, place of birth. Is it clear? It is an absolute right. Untouchability, nowhere defined. Now in this Article 17, you see the term now, in accordance with law, right? That is the meaning, that it is not self-executory. It will be executed by laws. Which laws? Protection of Civil Rights Act. Nowhere defined. Neither in the Constitution nor in the law. Okay? It is only on the understanding. Because if you are defining it, that means you are keeping it narrow. Then the people say, okay, options. Because in India, we are very discriminatory. We discriminate people on any ground. Okay? We discriminate people on any ground. We don't have any option. So we choose any of the choices. So if it is defined, it will mean that we are having option. Is it clear? Do you want options? No. You want it on the interpretation. Clear? But it is very, very clear, social boycott is not untouchability. Clear? Let us go to another article. What does it say? Article 18. What does it say? Abolition of titles. Very good. So the Constitution has abolished the title. Yes? Very good. But we have Sir Ravinder Jadeja. We have Lord Shardul Thakur. Yes or no? We have or not? These are the titles. Tell me. Officially they should not get. Yes. But if you are a doctor, then you can. Okay. If you are a part of defense forces, you can. Like we have the former Chief Minister of Punjab, Captain Amrinder Singh. Right. So that is allowed. Right. But the other titles are not allowed to be given by the state. Otherwise, you can call by any name. You can call someone sir, you can call someone lord, you can call someone whatever name you want to give, right? Because that is not given by the state. The state shall not give any titles. By state except military and academic titles. Okay. Done? That is Article 18. This is available for citizens or for all? It means it is available for citizens or abolished for all. It is a foreigner can also not have title in India. Indian government cannot give any title. Foreign government cannot give any title to Indian. They can give title to any of their citizen. Understood? Article 18 says any person cannot have title given by state. Any foreigner will not be given a title by the state. Any Indian will not be given a title by the state. But if a foreigner is getting title, how can we stop him or her? Approval. Okay. It is not banned. Be very clear. It is not banned for foreign citizens. Also, it talks about that if you are a citizen of India, you cannot accept gifts without the permission of the president. Okay. Is it clear? You have to take the permission of the president. Are we clear? Very good. This is Article 18. Now, after 18 comes right to freedom. Very, very important. Remember, whatever we are discussing today and tomorrow, 100% you understand? Question will come. Okay, if you understand 100% meaning of 100%, question will come. What we are discussing today and tomorrow. Okay, and if the question is not there, you know what to do? Run very fast. Is it clear? Because you are in the wrong center. Right to freedom, article 19 to 22, and do not look here. We will complete article 19, then we'll think. Right to freedom. It talks about article 19. Very good. You have heard about article 19? What does it say? Freedom of speech and expression, and this is the right that we use most, right? But we don't know what it actually means. Article 19, the most used rights, right? You must have commented on your social media account, it is my article 19, I can do anything, right? But we must know it. First, it is available to citizens or for all? Citizens. Very good. Now article 19 protect your 6 rights. It protects your 6 rights. What 6 rights is it protecting? First, your right to freedom of speech and expression. It includes your right to stay silent also. You have the right to freedom of speech and expression. You have right to stay silent including. आप कुछ एक्सप्रेस करोगे, अकेले में थोड़ी करोगे. मान लो एक बहुत गजब आइडिया, यूरेका मूवमेंट आया, आता है ना, क्या करोगे उसके बाद? बुलाओगे, असेंबल होगे ना, क्या आओ अनिल चाय वाले मिलते हैं, अभी भी स्टिल देयर, you are not aware of it? It used to be when we were aspirants. So assembly point, right? Or Agarwal sweets Kol Chakkar, it is assembly point. So if you do not have this right, what is the point of speech and expression, right? So you have right to assemble, but without arms. ऐसा नहीं you are coming with your dhanush baan, let us assemble, let us have expressions. Okay, you can assemble without arms. Very good. अब assemble होगे, कुछ तो डिस्कस करोगे, कुछ डिस्कस करने के बाद कुछ तो फाइनल कंक्लूजन आएगा कि आओ ग्रुप बनाते हैं. Yes or no? Very good. अब आपका राइट ही नहीं तो what will you do? असेंबल होके क्या करोगे? कुछ प्लान होगा तभी तो, राइट? तो आपने ग्रुप बनाया, ठीक है? वो ग्रुप क्या है? आपका राइट है, राइट टू फॉर्म एसोसिएशंस. Unions and cooperative. ठीक है? Now I am writing it with different color because it was not there in the original constitution. It was added through 97 Constitutional Amendment Act. The word cooperative. तो आपके दिमाग में ख्याल आया, अब सबसे बेसिक ख्याल क्या आता है? गोवा चलें. आपने दोस्तों से बोला अग्रवाल स्वीट्स में मिलो, व्हाट्सएप ग्रुप बनाया, गोवा चलें, ठीक है? सारे फ्रेंड्स को ऐड किया, ठीक है? आपके पास क्या होना चाहिए? कुछ पावर तो होनी चाहिए गोवा जाने की. यस और नो? यू मस्ट बी हैविंग अ पावर. इसीलिए हम लोगों के थाईलैंड के प्लान भी नहीं हम लोग बताते, क्योंकि वीजा की टेंशन रहती है, ठीक है? इसलिए हम लोग क्या करते हैं, गोवा का ही बनाते हैं. कैंसिल करें तो करना है तो कैंसिल ही है ना? सो वी शुड बी हैविंग राइट टू मूव फ्रीली. क्लियर? तो फोर्थ राइट इज राइट टू मूव फ्रीली. ओके, क्योंकि यू डू नॉट हैव टू पे एनी चार्जेस, इट इज फ्री. राइट टू मूव फ्रीली थ्रू आउट दी territory of India, right? Throughout the territory of India. अब in all such plans एक दोस्त ऐसा होता है जो पहुंच ही जाता है वो, ठीक है? अब that friend has reached, that friend will have to stay there, right? तो वहां फ्री में रहेगा, बिकॉज फंडामेंटल राइट टू मूव फ्रीली, तो राइट टू रिजाइड फ्रीली, नो, राइट टू रिजाइड ओनली. You have the right to reside, not right to reside freely. Okay, right to reside. Where? Throughout the territory of India. अब कितने दिन अपनी पॉकेट मनी से खर्च करो, कुछ काम तो करना ही पड़ेगा, है ना. तो गोवा पहुंचने के बाद that friend has to do something. That friend has the right to have any trade, profession, occupation or business. Right to profession. Yes or no? Yes? Very good. You want to see some jadoo? Very good. This is 19(1). This is 19(1). Right? These rights are mentioned as 19(1) A, B, C, D, E, G. Okay. These rights are mentioned as G. Alphabets also this faculty does not know. After E comes F. No, right? But we don't want to give any F in our 19(1), right? Because it has been repealed. That is right to property. So 19(1) F is there. Remember, 19(1) F is there, but it is repealed. Which Amendment Act? You all know. 44th Constitutional Amendment Act. Are we clear with this? So these are the fundamental rights under Article 19(1). 19(1). Clear? Any doubt? Yes, no? Now these fundamental rights, you cannot have any thought and expression. Thought you can have, but not expression. Thought so we can have any, but expression, for having that we need to have certain reasonable restrictions. Otherwise, if we have a thought that let us have party in the nuclear reactor, such a radioactive thought, right? So what you can have, you should have certain reasonable restrictions. So 19(2) to 19(6) have the reasonable restrictions. So 19(2) have reasonable restriction on your freedom of speech and expression. So let us see what are those reasonable restrictions. Right. So there are, yes, sure. Now the reasonable restriction on your freedom of speech and expression, it includes first that it should not be affecting the sovereignty and integrity of India. It was not there in the original constitution, it was added through first Constitutional Amendment Act. Okay. You must know that the limitation, reasonable restriction as respect to the sovereignty integrity of India was added through first Constitutional Amendment Act. Is it clear? Then you cannot do anything that is affecting the security of the state. You cannot do anything that is affecting the friendly relations with the foreign state. You cannot do which is affecting the public order, decency or morality, or in relation to the contempt of court, defamation or incitement of an offence. These are the reasonable restrictions. Okay. Reasonable restrictions. Are we clear? Very good. Now, nothing in the subclause. It means when you are talking about the right to assemble without arms. You can assemble without arms, but there are certain restrictions. What are the restrictions? That you cannot assemble anything which is affecting the security and integrity of the India, sovereignty, integrity and public order. Okay, public order and sovereignty, integrity. Otherwise, you can assemble without arms. If you are assembling at a place which is affecting the public order, your assembly can be restricted. Okay, for example, the roads, railway lines, that may affect the public order, right? So that can be restricted. Then you have the right to form association, union and cooperatives. You can form any association, but it should not be affecting sovereignty, integrity of India, public order and morality. Must ensure that any such association that you are forming, that should not be affecting the public order, morality and sovereignty and integrity of India. Right? You have right to move freely throughout the territory of India. Right? But you cannot, for example, you have right to move freely. So what you will do? You will knock your neighbor's house and enter like this. What are you doing? Article 19(1)(d). You cannot do that. Why? Because it is against the interest of general public. Right? And you cannot go to the tribal areas without inner line permit. Right? So these are the reasonable restrictions. Same are with the right to reside. You cannot do knock your neighbor's house and say, remove this sofa, I have to bring my bed, because you cannot do anything which is against the public interest. First thing. Second thing, you cannot do anything which is in the against the interest of tribals. Right? Right to property is repealed. Then there are reasonable restrictions which are on the profession, occupation, trade and business. You cannot have any such profession for which a professional qualification is allowed. For example, you cannot be a, let us say, BCom honors graduate and open a clinic of a doctor. Right? You have to have that qualification. Though in some places in India you see doctor and the qualification is BCom honors, but in place of that they are also written RMP, registered medical practitioner. So you need to have certain qualification to practice certain profession. Then you cannot have any trade which is monopoly of the state. For example, you cannot sell, let us say, petrol without a license. Right? You cannot sell alcohol without a license. Or you cannot sell something in which the state has monopoly. For example, you cannot open a shop selling nuclear radioactive material because the monopoly of the state is there. You cannot do or you cannot have any illegal occupation. You cannot have any immoral occupation because that will also be a violation of the norms prepared by the state. Are we clear? Yes or no? So these are the reasonable restrictions of Article 19. With this we complete Article 19. Do we have any doubt? Yes, no, no. So let us discuss questions till this point, right? Because this will make you understand what are the important points. Now look at this question, UPSC question. Question 1. Try to answer this. D. Remember the answers. Aadhaar card can be used as a proof of citizenship? No, it is a proof of residence. Right? Once issued, the Aadhaar card cannot be deactivated. Yes, it can be deactivated. Right? So answer will be D. Second question. B. Let us see. B, you say, which one of the following reflects the nicest and the appropriate relationship between law and liberty? First, if there are more laws, there is less liberty. No, rather more laws can provide more liberty. For example, the law that was to decriminalize the section 377, that provided more liberty. Right. Second, where there is no law, there is no liberty. May or may not be. Let us go to the other statements. Then third, if there is liberty, laws have to be made by the people, but it was not necessary. In a liberty, law may be made by the representative democracy also. In liberty, laws may be made by the crown also, in the constitutional monarchy also, not necessarily. If laws are changed too often, liberty is in danger. It may expand the liberty also. If the laws are changed too often, the answer will be B. Okay? The answer will be B, that if there are no laws, there is no liberty. Third question. See? So, which of the following are regarded as the main features of rule of law? So, first is limitation of powers. Yes, rule of law is limiting the powers. Let us see. Second, it is establishing equality before law. Yes. So, second is 100% correct. So, first will not be the answer. Right. Now, see, people's responsibility to the government. It is the government's responsibility to the people. So, it means third is wrong. A is wrong, D is wrong. So, answer will be either B or C. Let us see. Liberty and civil rights. Yes, it is about rule of law. Now, rule of law, is it having limitations of powers? Yes or no? Absence of arbitrary powers. It means it is putting certain limitations. So, answer will be C, 1, 2 and 4. Clear? Very good. Now, fourth question. C. It's a very simple question. Right against exploitation. Though we have not done it, but it is very simple. Prohibition of traffic in human beings and forced labor. Abolition of untouchability. It is under right to equality. So, 2 is wrong, 2 is wrong, 2 is wrong, 2 is wrong. Answer is C. Sometimes you may not know the correct options, but you know what is wrong. And most of the times, this will also help you. Clear? Right. Fifth question. See? You should answer, it is your choice, but let others also wait. If you have done it before, wait for others to also answer. Okay? Give 2 minutes at least. Okay? Now, let us discuss this question. Which of the following statements are or is correct? Rights are claims of the state against the citizen. First is wrong. This is not the claim of the state. Very good. Rights are privileges which are incorporated in the constitution of the state. These are not privileges. These are entitlements. You are not getting any privilege with the rights. You are entitled to your rights. Rights are claims of the citizens against the state. Not necessarily. We have to read all the options we have to read. D. Rights are privileges of few citizens. It is not a privilege. So answer is C. Okay. Now, read the statements and it is asking which of the following are not correct. Okay. Read the statement first. Tell me the answers now. A. But A, B, C, D are not visible, na? Okay, you have the answers also. A, C. Very good. Let us see. It amends the act to provide. It amends the act to provide the Hindus, Sikh, Buddhist, Jain, Parsi, and Christians from Afghanistan, Bangladesh, Myanmar, and Pakistan who are not in. The first is wrong. Myanmar is not there. Very good. The act provides for elect citizenship through registration. Wrong. Naturalization. Third, the act will not be applicable to the areas of 5th and 6th schedule. Correct? Incorrect. 5th is not there. It is applicable in Rajasthan. Rajasthan has scheduled areas. Okay. So that is why I say read the question properly. Okay. Because 6th schedule only it is covered, 5th schedule is not covered. Okay. Because 5th schedule areas are not necessarily those areas where migrants have reached. But 6th schedule areas are mostly areas which are on the borders of Bangladesh or Myanmar. Okay. Yes, it is also exempted, the areas of inland line permit. 6th schedule and inland line permit, both. Now, try this question. See, if all the questions we discuss are from the UPSC, then what is the point of the class? Some questions should be brainstorming. Storm. Is it visible? Tell me. B, D. A. Very good. Reason for A? Reason for A? It is not in the state. I remember Article 35, only Parliament has the power to make any changes in the fundamental rights, and it made changes in the fundamental rights 15 and 16. No need. Sometimes we think that the question is very difficult, but you just need to have the interlinking. Okay. So, where is the question now? Fundamental right, it brought changes and it is what we know. So, it is A. UPSC 2021 question. 21. Very good. Discuss this question. This is also 2021 question. This year's question. Very good question, but very easy. Done? Now tell me the answer. A, C. Let us see what is the answer. A legislation means law. A law which confers on the executive administrative authority, it means state. Any law, if it is giving a state authority and unguided and uncontrolled discretionary power, it means some privilege in the matter of the law which violates which of the fundamental rights. It means if a law is giving privilege to the state, it is violating what? Equality before law, Article 14. Understood? Question is simple. It's just that the language that they have used is little complex. We'll stop here today. We'll continue with fundamental rights tomorrow and discuss more questions related to it. Are we clear? Very good. Do we have any doubt? Please ask your doubts. Otherwise, we are concluding today's class. Thank you very much.